The winner of a $1.3 billion Powerball jackpot has sued his baby mama after he alleges that she violated a non disclosure agreement by telling his family members that he had won the lottery. Now, the man had claimed the jackpot using a legal tactic that allowed him to do so anonymously, and I'll explain that to you in a minute. I'm Kevin Kneupper. I'm an attorney at Kneupper & Covey, and I want to walk you through this crazy lawsuit. Here's an article about how this guy did it. And so he wins this $1.3 billion Mega Millions jackpot, and he uses an LLC, a limited liability company, to actually claim the ticket. So you can, in only 11 states are you allowed to claim a Powerball lottery anonymously. But what he did is kind of a trick. Instead of him claiming it, now he just transfers the ticket to this LLC, and it owns the ticket, so it's the one that claims it, and it's the one that gets disclosed instead of him. So the anonymity was important to him. You can see that he chose this cash value option of $723 million, and the company was called Lacoma Island Investments. So that's not the person, but he obviously has gotten someone to help him manage this, because most lottery winners do what doesn't make sense and just go in and start doing stuff. Having this planned out makes a lot of sense, and it looks like he has some kind of team behind him based on the filings in this lawsuit. And why does he want to be anonymous? Well, you always probably should be if you can, if you win the lottery. He obviously doesn't want people coming forward, and there's all kinds of risks, not just security risks, but risk with people, family members bugging you for money, the media going after you. There's another winner in California I've done some videos about who's got paparazzi after him all the time. He's got another person claiming that he stole the ticket from him, and all kinds of drama following it around, largely because his name was made public. So this guy successfully managed to stay anonymous until his baby mama started dropping it to people, and now he has sued her. Here's the complaint in the lawsuit. A complaint is the first document that gets filed, and it lays out what a person's legal claims are. You'll see in the upper left that it lists the person suing as John Doe and the person that he is suing as Sarah Smith. Now, these are both not their real names. They are pseudonyms. You can see at the very bottom of here, it says that plaintiff and defendant are both identified herein by pseudonyms for the reasons articulated in the plaintiff's motion to proceed under pseudonym and for protective order. Courts don't always allow you to do this. They will often allow you to sue defendants anonymously until you find their name. But in this particular case, they went to the court. They asked in a motion to say, hey, can I... The whole point of this is to keep myself anonymous, and claiming that a contract was breached that is going to reveal me. And so I want to do this anonymously, and the court for now has granted that. So you go through here, and it lays out what he's alleging happened. He says that he is a winner of the Maine state lottery, and that's the Powerball. And the defendant is, even though it says it's state lottery, he's the only one that is a $1.3 million lottery win this year is a Powerball from Maine. And the defendant, the person he's suing, this Sarah Smith, not her real name, is the mother of his daughter. And he says that because of the privacy concerns, the safety concerns, the security concerns, he had this baby mama enter into a non-disclosure agreement with him to promote his safety and to make sure their daughter was okay and make sure the media didn't find out about that. We have a copy of this NDA attached to the lawsuit. And a key part of this as to whether this is he going to win or not, that's kind of what you may be wondering, is this concept called consideration. So that's something where I think he may have some problems here, and I'm going to show you in this agreement, because he attached it, where there might be an issue with him if she can get a lawyer to go in or find a lawyer to defend her, which may be another problem. One of the issues with the American legal system is that the wealthy tend to have a huge advantage, because if you don't have lawyers, you have a real hard time winning legal cases. Consideration is something in a contract that is required to make it a valid contract. It means that both sides have to offer one another a benefit in the contract. A contract can't just be you making a promise unilaterally. It has to be an exchange of promises, an exchange of consideration. It doesn't have to be money. It could be something of value is the way that it's usually defined. So if both sides are giving something of value to one another in exchange for the contract, that's a key part to making it a legitimate contract. Now, what is the consideration that he says that she gave him? Because, or rather that he gave her, because she gave him something. She gave him this broad agreement to keep everything confidential that she wouldn't otherwise have to do. And he says that what he gave her is that he agreed to provide her support and ongoing security resources. And we'll look at that in just a second as to what he's saying there. And that could potentially be consideration, but it also can create legal issues for him here. So he talks about this non-disclosure agreement. He says that she's not going to disclose, she agreed not to disclose this to anyone other than people that he'd authorized as recipients of the information. And it goes through just some of the legal language here that is just general from a non-disclosure agreement. And Then there's all these provisions. There's remedies, which are what happens if it's breached. It lasts until 2032, which is when their daughter would come of age. And he says that in September 2023, he discovered that the baby mama, the defendant, had violated the non-disclosure agreement by telling, without permission, people about the fact that he won the lottery. Who are those? He says that in telephone conversations, she told his father and his stepmother. Now, why would that be an issue? Well, we all probably have family members who you may want not to know something like this. They may have, I think it's natural for people to want to tell someone something like this. This is kind of huge information. So I do sympathize with the baby mama to some degree, because that's a hard thing to keep your lips zipped about. And his family members, there could be all kind of reasons. It could just be that they're nice people, but that they are gossips, or they just don't have the fortitude to hold something like that until 2020 or 2032 and keep it private. It may be that they are we have, probably everybody has a black sheep in their family, and there may be people in your family you don't want to know. There could be just many reasons why he just wants to live a quiet life and not have people knowing that he is nearly a billionaire. And under this agreement, he says that she should not have done this, and she disclosed it to these people. What happened then? He says, well, now it went even further in his family. So then the father and stepmother told at least his sister about this. And he says there's other third parties who now know also that he's a lottery winner. And so he is suing her over this. What's he asking for? He wants his attorney's fees. He wants an order by the court that she would have to report to him in writing all the people to whom she told that he won the lottery, when he made the disclosures, how he disclosed it, and any efforts that she's undertaken to retrieve this information, and also reasonable attorney's fees that'll pay for his cost of bringing this lawsuit. Now, I will say one very unfortunate thing, and I'm not going to show this to you, and I'm not going to say it to you, but I know the guy's name. I can find the guy's name right in here, right? Like he said, I know her name too. Just looking at the legal documents, there's been apparently some screw ups. And there is, if you start digging through the record, it is possible to find this guy's name. His lawyers may be in for, they need to look a little more carefully about what they're filing before the court. I will say that, but I'm not going to reveal this guy's name or who he is, and respect their wishes for privacy on this. But man, you got to go through what you're putting in front of the court sometimes. He wants $100,000 for every unauthorized disclosure that she's done under this agreement. I don't know if he'll frankly still be able to get that, given he's got this stuff in the record. We'll see, or whether that affects anything. Let's look at the non-disclosure agreement, because non-disclosure agreements are very controversial. I don't think this scenario is one that a lot of people would have a problem with him wanting to stay confidential. That makes sense. There's security issues. There are reasons, like, I think it's frankly, we should let lottery winners stay confidential. It's not some huge public interest thing to know which person to go bother with all like when people want to go, beg for money or ask for stuff or harass them or follow them around or whatever they want to do. They shouldn't be doing it if the person doesn't want to be in the public eye for this. But in general, non-disclosure agreements have had lots of issues. There are a lot of people who are stuck under these for things where there are policy reasons that maybe that we shouldn't even be allowed to have them. There's a lot of people who think, and frankly, I kind of agree with this, that for people like Harvey Weinstein, maybe they shouldn't be able to enforce a non-disclosure agreement. There's a lot of people who think they're stuck under one when really they may not be. And this woman may not be. I don't know. We need more facts to figure that out. But looking at this consideration issue, it causes kind of two issues that I want to talk to you about legally as to whether, like, could you get out of one of these? Well, this is an example of how you can potentially get out of this depending on what the facts are, and we'll see. Here's the non-disclosure agreement. And a lot of this is legalese. This is probably drafted by his lawyers. That's one issue for him, is that if his lawyers drafted it, it's called a rule of construction. How do you construe, how do you interpret a contract? Well, one rule in general, and there's just really kind of guidelines for a court, which is that you construe a contract against the drafter, which means if one party has an attorney and there's any kind of vagueness, you interpret that vagueness against the person who wrote it, unless both parties are going back and forth with the right, or not just the right, but both parties are drafting the language and participating in the language. She may not have had an attorney. Did she? I don't know. The smart thing to do would have been pay for her to have an attorney, but there's some other issues in here, and particularly this consideration issue. So you can see they have all this kind of legal language. They have all this stuff about the breach, and here's the remedies, and let's find the consideration part right here. So this is it under covenant. And it says, for and in consideration of support to be given to mother and daughter by father in the form of ongoing security resources to ensure her safety, and except as permission may be specifically granted with the terms herein, the mother agrees to this confidentiality clause. So the only thing in this agreement that's potentially making it that's that consideration that he's pointing to is this promise to give her ongoing security resources to the mother to ensure her safety. There's a couple potential issues with this. One is he really needs to show that it happened, because the way that they wrote this agreement, the smart thing to do here, I'll say, would not to have been to do this. Instead of this, if he had given her 10 grand, just right in there, I will give you $10,000 for this NDA, he'd be fine. Like, it would be the best way to have done this. Best 10 grand you ever spent if you really want to make this enforceable, because that's simple. It's easy to understand and interpret. She gets 10,000. She promises confidentiality. It's more than what's called nominal consideration. It's a real promise for real money. And he would be sitting pretty on this issue. But this has a legal issue here now, because it was written this way, that the consideration was going to be this ongoing security resources. Well, there's two issues with that legally. One is that it's potentially vague. That's a jury issue generally, but it can be an issue with contract interpretation, that if a clause is vague, then the jury can decide, like, what did it mean, security resources, and is that enough to be consideration? Is it something that's really a promise and a benefit back and forth between the two? Because what is he even talking about with security resources? But second, and I think sort of more problematic, is that there's an issue here if he didn't give her, on an ongoing basis from the time they signed this agreement until the time she made the disclosures, some significant amount of security resources, or whatever that is, that would be the consideration. And if he stopped. So if he stops this at any point, it's not ongoing. And if she can show that there was any period where he wasn't giving her security resources, then that is a breach of the contract, because that's a promise he's making. I will give you these ongoing security resources. Why is that a problem for his effort to sue her under this contract? This is a legal case in Maine. If you've never seen a legal opinion, their judges, whenever they decide a case, not always, but a lot of times, they will publish we'll call it a legal opinion, and it is just a written, often lengthy explanation and citation to case law of why did the judge decide all the various issues in the case the way that they did. The point of these is to give either guidance or binding decisions for other courts. There's a whole complex hierarchy of when a decision is just a persuasive decision, when are you forced to follow it if you're a court, but the idea is basically to lay stuff out so that when other courts confront similar situations, they know what someone else did, and they can use that to determine their decision, so that judges aren't just constantly redeciding the same issues over and over again. This one is interesting. It's a general principle that could, if this security stuff was not ongoing, that would create huge problems for him. And the reason is because of this legal principle that exists in Maine. I'm trying to find it here. Here it is. And also everywhere. It's everywhere I know of. I can't promise in your state that this is true there, but every state that I've looked at has this, because it's sort of a general contract principle. And in this case, there was a breach by one of the parties to the contract, and then the party that breached the contract tried to sue the other one. That happens. It's pretty common that you'll find people sued under a contract, and one of the easiest ways to get out of a contract or an NDA is if you aren't the first person who breached, because you can see this says that this company, Oak Ridge, was excused from further performance under the contract. And over on the left, it says that the Howland's breach of the contract was a material breach and excused Oak Ridge from further performance under the contract. So that will apply in Maine, and that is just this general principle that the first person to breach a contract materially, that means in some kind of important way, you can't just be the most minor clause in there, but something that kind of matters to the contract. It was an important part of the deal. It doesn't have to be, the single most important thing, but something that was part of what the parties were counting on in their agreement. And here that would the security stuff, ongoing security, would definitely be part of what they were counting on. If he breached that first, she's totally, she didn't have to do anything else on their contract. She's excused from performance is the phrase. And so for people under NDAs, this is the first thing you should look at. Is there anything in that contract that is not a minor term, that's something at least kind of significant that the other person has breached first? Because once they do that, you are out of all your duties. Now you have to get lawyers and go into the end to do this. She's stuck in this lawsuit now. Can she afford lawyers? I don't know. Did he breach the contract? I don't know that either. And frankly, I don't know if any of the allegations he's making are true. We don't know that until it goes before a jury. What we have right now is allegations. But because so many people are locked in kind of these NDAs, I want to make sure y'all know, you're not necessarily stuck. If you are in some contract like this and the other party doesn't follow through with any of the things that they said, you may be able to actually get out of whatever contracts you're in. So that's probably just looking at this sort of ballparking, spitballing, what could she do? Looks like she might have a way if she can show. I mean, maybe he didn't give her a security team. Maybe he. It, the reason I'm saying this and the reason I'm guessing is just because it sounds like something that was written in there for the purpose of being making the contract legitimate. And if he didn't follow through, he's going to be in trouble trying to get any of this, and maybe she'll be the one getting attorney's fees. What happens from here? Well, he still has to go to trial to prove his claims, and he probably has to be a little more careful about what he's filing with the court. And, frankly, there are a lot of ways, if this goes to trial, that his identity could come out even more generally, even aside from botching some of the filings. But we'll see. Hopefully this isn't all over the media and this guy gets to keep a little of his privacy, and hope, this could be some family dispute when you start suing people who are, the mother of your daughter. Sometimes it may be about this, but it may be about something else, right? If their relationship has gone sour. A lot of lottery winners have had their lives destroyed by winning the lottery, and we can only wish them luck and wish them both luck and hope that it turns out well, at least for the daughter as well. Want to see more videos about crazy lawsuits? Hit subscribe.